Hello and a very warm welcome to this eighth TED Talk that is being presented by the CPR CWC Dialogue Forum at CPR. I am Srinivas, Dr. Srinivas Chokkakula. I am the MoJS Research Chair on Water Conflicts and Governance. MoJS Research Chair is established by the Ministry of Jal Shakti, Government of India, to support research on transboundary water conflicts and cooperation at CPR. And we collaborate with the Central Water Commission, Government of India, in creating as well as nurturing this dialogue forum, which is CPR CWC Dialogue Forum. And we called it TED Talks. We call these talk series as TED Talks because it is, there is a small group around this research chair that we formed, which consists of researchers who are interested in transboundary rivers and their governance generally. So we have this, you can see the threads behind me, which is actually the acronym is for Transboundary Rivers, Ecologies, and Development Studies. So we took it, extended it, and we call these talks that we present under CPR CWC Dialogue Forum as TED Talks. So this is the eighth of the talks, but these are not always as talks. There could be, we have the earlier TED Talks were organized as roundtable consultations. We also organized workshops under these TED Talks. And we also addressed various themes, though our focus remains on transboundary water conflicts and resolution and enabling cooperation, with special focus on interstate river water disputes and interstate river water cooperation. We also address beyond that topic, topics that issues that are contemporary and of interest to the broader, within the landscape of water governance. So, for example, we have had a couple of talks addressing the, quote unquote, water crisis we had in July 2019. And we wanted to continue them as we go, but, we have had a kind of break for obvious reasons of Corona in our own transformation from, real TED Talks to virtual TED Talks. But right now we are back and we are going to have more and more talks on a regular basis. So before I introduce the speaker today, I just wanted to set a couple of logistics rules. Primarily, we are, the speaker is going to speak for about 40 minutes. So let us say if we started around 3:40, we will have up to 5:15 or 5:20. Is it 4:20? And then we will open up for question and answer session. That question and answer session requests you to put your questions in the Q&A space that Zoom allows. But otherwise, you are free to continue to have comments and exchange notes in the chat box. Since this, our experience has been that it is the chat box becomes very active as we progress with the talk. So it's very difficult for us to pick up the questions that you want us to address to the speaker. So I'm going to help him out, help the speaker out, but at the same time, he would be looking at the Q&A space and then responding to those question and answers. So please use Q&A space for putting up your questions, and we will only use that. And if we have the luxury of time after addressing all those questions, then we can allow some of those speakers who would raise their hands, some of those attendees who would raise their hands and ask for, speaking out or otherwise sharing their opinion or comment about something that is said. But with our experience, it doesn't happen. We would have plenty of questions. So use that Q&A space, efficiently and, actively, but only to focus on questions that needs to be addressed by the speaker. Otherwise, feel free to put in your comments. Feel free to introduce yourself, or feel free to say anything that is sensible and relevant for us, or otherwise add some information that we may have missed, or otherwise you think that we do disagree with, I mean, you think that there are something that is contradictory to your own belief, but use that in the chat space. So these are the ground rules for this webinar. And with that, and without further ado, I have real pleasure of introducing Mr. Mohan Katarki. He's actually should be quite well known across the board, partly because, I mean, just to the fundamentals, he's a senior advocate at the Supreme Court of India, and he is an expert on, I hesitate to use the word expert, but he's the true real expert on transboundary law, water courses law. And the reason why is, I mean, you don't even need me to substantiate it, because as you may have read it in the introduction to the speaker, he pretty much is part of the team of every state that is now part of the any interstate dispute that is right now currently going on. So if you look at those states that are mentioned in his introduction, so if you take out the first generation of those tribunals, the first Godavari, Krishna, and Narmada, I think the rest of all the tribunals, you would see Mr. Mohan Katarki joining and then, fighting for one or other state. So that itself shows the kind of, the practicing experience that he brings to the table. And obviously, these are those people who have seen closely how these highly codified international law principles are applied in particular contexts. So, I mean, you may have heard about international water law, transboundary law in classrooms, but to hear it from a practitioner perspective would be entirely different ballgame altogether. And I can tell you, I can vouch for it, because I have had opportunity to, first of all, knew him for a long time. I have known him for a long time. In fact, he was a great support during my own dissertation, writing when I was doing institutional ethnography of tribunals at one point, and then was such a great support and always willing and always generous with his time as well as inputs. So it's a real pleasure to have you, Mr. Mohan Katarki. Over to you. You can introduce the topic and then take over.
Thank you, Srinivas. It's really my pleasure to speak on this occasion today. May I first thank the CPR and CWC for organizing this talk, that on a subject which is not much discussed elsewhere. International law and its response to challenges of shared river waters is really a topic which generates interest more among engineers than lawyers. The lawyers have been trying to catch up with the subject, no doubt, but basically the engineers, particularly engineers working on the water resources planning, who are more interested in the subject. The outline of my talk it's in two parts. The first part is international water law, and the second part is its response to challenges of shared river waters, the responses which the law is facing with regard to certain issues that have arisen in the last decade. As you all know, international law is broadly divided into two categories: lex lata and lex ferenda. Lex lata is the law as it is, as it exists. Lex ferenda is law that we wish it changes and accommodates the changing socio-economic values in the world. The international water law is founded on two basic principles, in my view. The first principle is the flowing water is res communis, that is negative community or public trust. No state has any possessory rights in the flowing water. States have only right to use, or in law we call it usufructory rights. This is the legal position, in fact, with regard to the private law also. When you say that riparian owner has a right to use water, it is only right to use water. He has no right to the possession of the flow. Possession of water comes only if you enter into an agreement, or if you have a share allocated, build a dam, store it. That could be a water over which you have possessory rights. Otherwise, in the flowing water, the water which flows by gravity, nobody has possessory rights, but all have, that is, right to use water. All means riparian states. Secondly, the most fundamental principle of international law, in fact, that is the only point on which international law stands, that is, states are sovereign and all are equal. This concept that states are sovereign and all are equal rules out any higher law or any higher authority to dictate terms. The international order does not have an international parliament or a legislature to make a law. There is no international court of justice with compulsory jurisdiction. That means an aggrieved party can go and sue for remedies. There is no such a forum at all. All that can be expected in an international forum is, if parties agree, they can submit it to International Court of Justice. The agreement could be express, or it could be a part of some prior treaty where parties are agreed that if any dispute arises with regard to the violation of treaty, it shall be adjudicated by International Court of Justice or by some arbitration or some forum, whatever. Like we have in Indus Treaty, a compulsory forum. That is, if India or Pakistan has any grievances, they will approach the World Bank. World Bank, having regard to the nature of the dispute, can constitute a neutral expert if it involves determination of any technical matters, or an arbitration if it involves both technical as well as legal matters. So the heart of international adjudication is a consent, and without consent, nothing happens. There cannot be any law. There have been many suggestions that in a strict sense, international law is not a law. It is only international morality or a soft law. This is how it stands. Now, with regard to the water, international law intends to regulate rights of each riparian state. The question of regulation comes when there is a conflict. When there is a conflict between the two set of rights, that is, if lower riparian and upper riparian have a conflict with regard to the sharing of the water or use of the water, then what is the approach of the law to solve that conflict? There where the international law comes into picture. The first such dispute arose was with regard to the river Rio Grande in 1895. The US Attorney General Harmon enunciated a very interesting doctrine that was strictly based upon the theory that states are sovereign and they owe no obligation to anyone with regard to the exercise of their rights. So it is called Harmon Doctrine when Mexico raised its objections against the United States of America. But Harmon Doctrine did not yield a satisfactory result. Couldn't have yielded also, because downstream states were left at the mercy of upstream state with regard to the water which they have been historically getting by flow of gravity. Naturally, in response to this extreme proposition of Harmon, the doctrine of natural flow arose, and natural flow has its foundation in the private law, because in the private law, the riparian law is let the river or water flow in its course of nature. The riparian owners have a right to take water without diminishing the flow. So this natural flow theory was propounded by downstream states. This theory, if taken to a logical end, will result in benefiting the downstream state by default, that upstream state cannot take the water, which will result in diminution of the flow, material diminution of the flow. And the downstream state also may have the same right, but since there is nobody to complain below the downstream state, so before going to the sea, the downstream state can very well utilize all the water. So this theory was condemned on a ground that by default, it helps the downstream state. There are no international treaties or agreements which have been entered based upon these two doctrines. We have not come across anyone as such. During the negotiations, usually upstream state highlights the virtues of Harmon Doctrine, and the downstream state highlights the virtues of natural flow theory. And it happened, as the records show, in case of Indus also. Pakistan did highlight natural flow theory. India did highlight Harmon Doctrine. In the clash between these two doctrines, naturally, a wire media has to be looked in, which will result in equal treatment or a fair treatment to both upper and downstream state. As I already said, one of the basic principles of international law is equality of states. This is the principle which has been the basis of international law right from Westphalia Treaty in 16th century. So if states are equal, they are not only sovereign, but they are equal. If they are equal, then they have to equally share the water. That's how the concept arose, why there should not be a equal sharing of water. But equal sharing of water again leads to a problem, that on what basis you share water equally, which might result in water going as waste to sea. Therefore, the concept of equitable came in place of equality, in place of equal share, rather would say. So equality of states led to the emergence of equitable utilization of water as a doctrine. So this is the doctrine which has been now for the last 5 to 6 decades governing the relation between the sovereign states with regard to their utilization of waters of international river. There are about 264 international basins. At least half of them do face some sort of conflicts, and many of them have been resolved by an agreement, because agreement is the only mode to resolve the disputes in international field. Even if there has to be adjudication, the adjudication also has to be by way of an agreement. And there are at least about 30 to 40 agreements which govern international basins around the world. The important among them is River Nile, Tigris, Indus, Mekong. These are the rivers which are presently governed by some sort of agreements, although in case of Nile, which I'm going to deal later, there is a serious dispute that whether two states, downstream states, can have an agreement to the exclusion of other and develop and then claim a right over that. So in this background, the doctrine of equitable apportionment has come into picture, which has been the law governing the conduct of the states. The International Law Association, a private body of jurists, took upon the task of codifying the international water law and add their progressive ideas. Their first effort was known as Helsinki Rules of 1966. It was a great achievement. After a series of conferences, resolutions, the International Law Association was able to arrive at a consensus on the rules which can be called codified rules with regard to the utilization of waters of international drainage basins. Subsequently, it was felt that Helsinki rules require a revision in the light of experiences that the world has faced. Again, a water resources committee was constituted. The committee went into the question threadbare. There was a report of Della Penna, on whose report the committee deliberated. Finally, rules were finalized and accepted in the ILA conference at Berlin, and these rules are known as Berlin Rules 2004. Simultaneously, United Nations also decided to, in its official capacity, although there's nothing like an official in international field, because there's no international parliament or a governing body, but United Nations has semi-official status in the world. The International Law Commission was entrusted with the responsibility of codifying the international water law or international law with regard to the non-navigational uses of waters of international water courses. In 1997, the convention was adopted by the General Assembly. Finally, it was open for the states' ratification, and the required number of states have already ratified, and the convention has been in force. Although India, Pakistan, or China, or Bangladesh have not ratified this convention. So strictly, this lawmaking convention, this is only a codification of the law. In international law, we call it a lawmaking convention, is not applicable to any of India or her neighbors, but it can be used as a guidance. In fact, some authors have gone to the extent of saying such a convention acquires the force of customary rule of international law if it is been accepted by a large number of nations and adopted. But that's a debatable question. Now, if the rules of equitable apportionment are codified, crystallized in a proper written form, what is the difficulty? Why can't states follow that and reach at an agreement? The problem is, these rules are not mathematical rules. These are basically the guidelines addressed to the disputing states or to the international adjudicating authority if established by consent or agreement, how to exercise their powers or rights. The equitable share of a state becomes a crucial issue. Once an equitable share of a state is determined, then whatever the activity the state carries on has to fall within the four contours of the equitable share. And if it falls within the equitable share, then it is legal. If it doesn't fall, then it is exceeding the share, the activity of a state becomes illegal. So whenever a dispute arises, nobody goes for the determination of equitable share without there being a cause of action. Usually these things arise if there is a cause of action. When a cause of action arises in a basin, how do they resolve? This, according to me, falls into three categories. It's my experience. Virgin basin, semi-appropriated basin, and fully appropriated basin. In case of a virgin basin, if there is a proposal for a dam in the upstream state, or a proposal for a dam in the downstream state, and upstream state feel there could be a prior commitment of the water, the dispute can be solved much easily because it's a virgin basin, there is enough water. All that is required is to solve the misgivings of the parties, to solve the misunderstanding of the parties, which we have all seen. Competent engineers can sit across the table and arrive at a solution. But the difficulty arises if there is semi-appropriated basin and fully appropriated basin. I mean by fully appropriated basin, what I mean is there are basins before any law or any international order came into picture, have by their natural process appropriated the waters of the river. This usually happens in case of any river because every river has a system, as you all know, mountains, then there is rolling land, then there is a delta. Deltas have been historically utilizing the water because they had no choice. It is a natural drainage system. They lived with the flood and they made use of the water when it was useful. As a result, in any river basin, it is the delta portion who constitute the first users and some low-lying areas in the upstream portion. But much of the water, whether it is the Nile, Mississippi, or Ganges, Brahmaputra, which are common delta, Mekong, or anyone you take, it is the delta portion which uses the water and has committed utilizations. So when a dispute arises, it's really a difficult task for the international law to deal with such a dispute because there are already established uses, established rights. There is already an established economy which cannot be disturbed. So if that is the situation, how do you accommodate the aspirations of the upstream state, which did not have the technology in the past, at least till the middle of 19th century, to build high dams? Now the technology has come and they too have a legitimate right to utilize the water. And how do we accommodate the aspirations of the upstream state and the existing utilizations, committed utilizations, prior uses, whatever name you call, of the downstream state? So this semi-appropriated, particularly fully appropriated basin, do pose a serious challenge. And these are the basins where really Harmon Doctrine was pressed by the upstream state, natural flow theory was pressed by the downstream state, and even after the introduction of the doctrine of equitable apportionment, that internal antagonism between the two, that rivalry, antagonism has not disappeared. Still, the same issues come back in a little different form as we see it. So, one of the foremost tasks for the Helsinki rules, formulated in 1966, was how to resolve such a conflict. It provided in Article 8 for continuation of the existing use unless the upstream state or the new user demonstrates the countervailing equity for termination of the existing use. Then came Berlin Rules. Berlin Rules has taken a little different view, a liberal view, trying to balance both the interest of existing users or waters which have been appropriated and the new users. Same is the case of UN Convention of 1997. There too, things appears to have been moved towards balancing approach. In the Berlin Rules, if you look to the Article 16, transboundary harm, it says a state shall not utilize water which will cause significant harm to the other state. Fine. If the harm is indeed caused, then that has to be resolved by reference to Article 12, that is equitable share. It looks fine. But what prevails? Which prevails? Whether ultimately the equitable share of a state prevails or existing use which is to be protected under Article 16 prevails. This is a matter on which there is no definite opinion at all. And there cannot be, I think. It depends upon case-to-case basis. That's why in the legal parlance, we say each river basin is sui generis. Sui generis means it's unique. There are various factors which have to be balanced, which have to be looked into before a judgment is arrived at on whether the existing irrigation, the historically cultivated irrigation requires to be protected, and whether the new irrigation or the new water use proposed by the upstream state should be given a priority. This issue is addressed from various angles. First, they try to find out what is the legitimate use of the downstream state, what is the actual water required, because the rule of equitable apportionment dictates and commands that no state has a right to waste water. In fact, US Supreme Court went to the extent of saying right to water exists only in utilization, as I said also at the beginning, right to use. And if the water is wasted to sea, that state does not have a right over that water. That wasted water can come back to the pool for division among the riparian states. In fact, nearer home, India and Pakistan under the Indus Treaty had divided cleanly 3 rivers to each other. The 3 rivers which are inured to the Pakistan side, the treaty says India shall let all the water except whatever is permitted to be utilized, and some rights are given for hydropower generation, provided those hydro plants comply the requirements specified therein. After all this, the 3 rivers which have gone to the Pakistan share, Jhelum, Chenab, and Indus, generate about 146 MAF of water on an average. I'm not giving an exact figure. I'm just giving a figure approximate. The available information is that not more than 110 MAF of water the Pakistan can utilize by use of the dams or the structures they have constructed or they can construct in future, including the Kalabag Dam. If that is the case, about 30 to 35 MA of water goes to sea. Yes, it does go to sea. There is no doubt about it, nor Pakistan has disputed that. That's what I learned, subject to the correction. So what is the status of this water? Certainly, Pakistan has no right in the context of larger rule of international law. Well, the treaty requires India to let down the water, means allow it to flow by gravity after exercising its limited right of whatever permitted in the state of Kashmir. The rest has to go down. And is it a right? And do they really have a right over the water which goes to sea? Or should it come back for reconsideration in the light of the experience of last 45 to 50 years? And both the states should sit and decide with regard to that. This is a question which is to be discussed at the level of two governments. I'm not going much into that, but I just stated it by way of an example that when a dispute arose, when the question arose, how to determine equitable share in the context of some dam or whatever the cause of action arises, the question whether a use by a state is wasteful or non-wasteful falls for serious consideration. In fact, when such a issue arose in the disputes between the states, in the federal states, in India, in Kaveri or other water tribunals, courts have gone to the extent of calculating the water based upon what is the rational duty by applying crop water requirement technology. Therefore, it's not that downstream state gets protection to all the water. It does get, but it has to be a water which is reasonably required, which is not wasteful. Same doctrine also applies to upstream state. Its aspirations, its right to develop does not mean it can just take away any water because no water is sufficient. And it can't simply justify by saying it is required for irrigating the lands. I have large lands, I want to irrigate. That doesn't solve the problem. It too has to explain why this water is really required, and its proposals do constitute a reasonable use of water based upon rational duties and the modern technology applied in transmission of the water. Besides, there are other questions arose, climatic factors, the socio-economic status of the state, whether it is poor or it is already a developed state. All these factors arise. But consideration of the factor as a whole is required while arriving at what is the equitable share of a state. After applying several principles of equity, these are the principles which are popular in the English common law. There are 7 or 8 principles of equity which we apply. So every situation, every kind of a problem that arises in adjusting equity has to be tested on the basis of the principles of equity and finally seen what is right, what is wrong, and share is assessed. Of course, many say what is equitable is nothing but Chancellor's foot. The courts of equity in England were presided by Chancellor, And when they say chancellor's foot, means whatever judge thinks equitable is equitable. To some extent true. The fact finder, adjudicating authority, whoever it is, exercises lot of discretion in finally coming to the conclusion as to what is the share of each state. That's how it is. Now let me move on to the next question. Whether the states, in international parlance, sovereign states, have a right to conclude a treaty ignoring the rules of equitable apportionment or on any other basin they think it is convenient to do. The answer for this question is difficult. It is res integra, not resolved. If you look to the Helsinki rules or later Berlin rules or UN convention, they all start by saying, if there is already an agreement, these rules do not apply. That means if you want to contract out in a way you like, you are free to contract out. This is how it is understood. But there is also an argument which I tend to subscribe, that is, any agreement which is inconsistent with the peremptory norm of international law or just cogence, that agreement is void. If the rules of equitable apportionment are the rules which have attained the status of peremptory norms of international law or just cogence, then there cannot be an agreement inconsistent with rules of equitable apportionment. Parties are not at liberty to contract out on a basis they like. A strong nation cannot impose its will upon the weak nation and dictate Harmon Doctrine, or it could be reverse. A downstream strong state cannot dictate natural flow theory on weak upstream state or any other basis. So I doubt it is, but this issue is yet to be resolved. This is one thing. Secondly, if there is already a treaty, it is going to bind the states. And if the opinion is that even if it is inconsistent with the international law of equitable apportionment, still it holds good, if that were the opinion. But still there is a principle which allows some kind of a interference or needling into the treaty by importing the rules of equity, because doctrine of equitable apportionment or this part of international law is erga omnes, that is, it is a principle which can be used by a fact finder or adjudicating authority if the dispute arises and it goes to the adjudicating authority to needle a bit or apply a post hoc check, they call it, and see whether it does conform to the rules of equity or not. So this is how the disputes in international basin are resolved. Whenever a cause of action arises, whenever the plans of two states are inconsistent with each other, whenever one state feels that the proposal of other state is going to cause an injury, then you go to the root of the matter, try to determine what is the equitable share, then see whether that proposal or a plan or a reservoir meets within the equitable share or not. If it does not, then we'll further go into the questions whether it prevails over the already committed utilizations, etc., and they require some kind of adjustment. But If once an equitable share is determined, almost the fate of a state is sealed. It has to work within that share, no doubt about it. Right. Now, going to the next topic, hotspots. There are two hotspots today in the world. You must have all read, where international community is certainly concerned about. One is Grand Ethiopian Renaissance Dam planned by Ethiopia across Blue Nile. The other is cluster of dams planned by China in the upper Mekong. With regard to the Grand Ethiopian Dam, it's really a serious matter. So far, we heard till 2010, in every international forum, there used to be a fight between Egypt and Sudan. For 100 years, Egypt and Sudan fought it out as to the respective share in the Nile. In 1959 treaty, it was decided to agree that total water available up to the High Aswan Dam is about 84 BCM. After reserving 10 BCM towards evaporation losses, Egypt was given 54 BCM. Sudan was given about 16 BCM approximately. Then they forgot that there are 9 more states above them. They assumed as if these states are never going to develop a water. But they kept some kind of a window. If some utilization of water is claimed by the upstream states or non-participating states, then that quantity of water, which is their equitable share or a share, has to be deducted from the shares of both Sudan and Egypt equally. Well, that is how the Treaty of 1959 Nile was arrived at. Now, Ethiopia wants to construct, and rather it has constructed already, a dam. It's called Great Renaissance Dam. The capacity of the dam is 64 BCM. The available water up to the dam site is only 59 BCM of water. Therefore, it is a dam constructed for carryover storage or storage higher than it, so that it can catch the water in the surplus years. In fact, Aswan Dam is also constructed in a similar fashion to catch surplus water. The reservoir is huge, more than the average flow that is available up to Aswan and the share of Egypt. This dispute on Renaissance Dam has become a serious in the international community, because Egypt, Ethiopia, and Sudan are on the Suez Canal. The Suez Canal is a critical link for a trade between the Europe and Asia. 13% of the world trade passes through this canal, which started in 1869. Therefore, if a conflict were to flare up between Egypt, Ethiopia, the canal may get blocked and international community would suffer. Therefore, the international community has taken keen interest in trying to resolve this dispute. In fact, United States of America also has stepped in. But so far, it appears there is no solution to the dispute. Ethiopia had entered into an agreement in 1902 that it shall not construct any project across Blue Nile or any of its tributaries. So that has to overcome whether that agreement still survives and to what extent it is relevant. Secondly, Ethiopia has to answer the claims of Sudan and Egypt that they have already utilized about 54 plus 16 MAF of water, including 10 MAF for evaporation losses. That means almost 84 BCM of water, not MAF, BCM of water has already been committed in the Nile Basin. And that 84 BCM includes about 60 BCM that flows down from the Ethiopia. Therefore, this is really a serious dispute which requires to be resolved in a fashion of give and take and what is equitable in the given circumstances. Both the states, I think, namely Ethiopia upstream, downstream, have to sacrifice their claims. The fine rules of equity, the modern technology have to be employed to see what is exactly the water requirement of Egypt. Is it 54 BCM? Whether Sudan requires 16 BCM? Can they not live with lesser water? And if some water can be salvaged in the downstream, it can be appropriated by Ethiopia, and also Ethiopians' proposal for such a high dam to produce large power, whether that is really required, to what extent is legitimate, what is not legitimate, to what extent it is commercial, what extent a power can also be met by alternate resources. These are the considerations which three states will have to address and arrive at an agreement. If not, they'll have to submit to some fact-finding body or arbitration or International Court of Justice. But as I already said, no adjudication can be forced upon. It can only be by consensus of the parties. So this is Grand Ethiopian Dam. Now let us see Mekong. We are all very romantic about the Mekong because the states went ahead and created a establishment under the Mekong Treaty. Mekong Commission is there to look into the development as well as the conflicts. But the main state where the water comes from, namely China, is not a full member of this Mekong Commission, and it doesn't want to be also. Now that China has planned series of dams in the upstream, and China says, well, I have a right to construct. I forgot to tell one important principle of international law, which was recognized in the Lake Lanu arbitration, that in international law, a state has a right to proceed unilaterally with the construction of a dam. It need not wait for the consent of other state. The tribunal said, the arbitration in Lake Lanu, insisting a state to wait for the consent or to proceed only upon an agreement amounts to giving a veto power to the other state, because other state will never agree for any agreement. So the state which wants to develop can never develop. Therefore, such a situation in international law is not recognized. A state is free to unilaterally go ahead with the construction of a project. What steps the aggrieved state should take is a different matter. There are obligations on the state which unilaterally proceeds with the construction to supply the information, to be transparent, to negotiate the issue in a bona fide manner. It has a duty to cooperate. All those things are there, but it has still a right to proceed unilaterally with the construction of a dam. This is the basic principle which we must all remember. That's how the problems arise in the international field. So in Mekong, the China has proceeded and constructed. Now there are studies, one by Cambodia and Vietnam, stating that last couple of years drought which they suffered was really because of these dams constructed by China, which are, according to China, are only hydropower dams where there is no consumptive utilization of water involved. China says nothing as such. My dams rather have been helping the downstream state to get some water in the summer after production of the power. The independent study conducted by Germany, some scientists in Germany also do side with downstream state. The larger opinion that has been emerging, as I could read in the magazines and the newspapers, is that China has indeed constructed bigger dams, oversized dams. Then the question is, why have they constructed? Here what many have been arguing, including Brahmachalani, that weaponization of water has started in the world. If an upstream state constructs a dam or construct number of dams more than the water required for legitimate use, will they use that as a weapon to bargain with the downstream state for some other things in their international conduct, in their international relationship? This is a very serious issue which needs to be addressed. When we consider what are the responses of challenges broadly, one is the climate change. Secondly, it is environmental concerns. Third is, which I already mentioned, weaponization. How will international law address to these three challenges is to be seen. Whether the existing international law is sufficient, whether further developments lex ferenda are required, progressive developments, and what are those if required. These have to be spelled out soon. If you look to the climate change, we're all concerned that climate change, though it is a hypothesis, though
Katarki,
it is a, yes, I'm already.
We have quite a few interesting questions. Yeah, pass it. Can we wrap it up in the next 3 minutes? Is it?
Yeah, I'll just wrap it up in 2-3 minutes. Okay.
Yeah.
The climate change is a possibility. May or may not happen, is a different matter, but it looks to be a possibility at the moment. And if, based upon the possibility, a state asks for revision of the existing treaties or factoring the climate change in the resolution of an international dispute based upon equitable apportionment, to what extent this can be taken into account? The only principle at the moment which has appealed to everyone is precautionary principle. Based upon the precaution, keep a window in case climate change happens, the water goes down, then you'll have to share it in a manner which is equitable to both. Equitable doesn't mean pro rata sharing or proportionate reduction. Well, American Supreme Court has said proportionate reduction appears equitable on the face of it, but it may not be on a deeper consideration. It may or may not be finally. So they will have to consider that. Weaponization, as I already said, depends upon the size of the dam. Some sort of international concerns, some kind of a rules have to emerge defining the capacity of the dam in relation to the water which is supposed to be used, that is a designed quantity of water. So if something like this can be worked out, weaponization can be controlled. And equally, there are obligations for ecological flows which have been recognized. In fact, recently in the dispute between India and Pakistan, Kishan Ganga, the right of a downstream state for ecological flows was recognized, though it was not a part of the treaty. So the international law has been responding to the challenges in its own way. India has vital interest. It is an upstream state in Indus, it is a downstream state in Brahmaputra. It is also concerned with the weaponization of water that could be possible if China were to construct more dam in the Tibet or link the Brahmaputra to Angchi, which has already been linked to the northern side by south-north diversion project. So these are all the concerns. Hope the international law will be able to grapple with that. And much depends upon how the science grapples, because the science, as I already said, itself is still not clear about the hydrological cycle. It is an applied science, hydrology. It has its own limitations. So in these circumstances, both law and technology, if I can use the modern phrase, should grapple to resolve international water disputes. Thank you very much. I'm open to questions.
Thank you. No, thank you. Thank you, Mr. Katarki. I mean, this is really fantastic. I know it is how difficult it is to put such a complex issues in such a simple language and for a wide-ranging audience. I know it's an amazing talk. And I also agree with you that these new challenges that are emerging, I'm not sure whether weaponization is new, but climate change, and then now more a kind of collective responsibility to respond to the larger risks attached to disasters, natural disasters. I think I don't know whether international law is as actively responding to it, whether it is through ILA or ILC. I guess it is ILC which is active now. But I think these are things that are still remaining unanswered. I'm sure it will take much longer time. We have actually very interesting questions in the Q&A space. I'll request you to just look at quickly at those Q&A, otherwise I can read them for you. But till you do that, by the time, I would like to, I mean, I'm quite excited as well as, really surprised. It's such a pleasant surprise to have these distinguished persons joining us. One is the chairman, Central Water Commission, Mr. R.K. Jain, whom you met just before initiation of the talk. And then we also have Mr. S.K. Halder, who is the member of Water and Planning, And I would like both of them to come on board, and they are also partners in hosting this, in fact, CPR, CWC Dialogue Forum. So I would like them to come on board and say a few words or ask questions. I would like to give them, with due apologies to attendees as well. And then I have also our own CPR's Professor Rangachari, who was those people who knew the pioneering work that came in 1990s on regional cooperation over water resources, which included Professor Rangachari and then Professor Ramaswamy Iyer and then Professor Varghese, DG Varghese, whose book is quite popular, which is Waters of Hope. We have Professor Rangachari as well joining us, who also happened to be a former member of Central Water Commission. So I would like him to also come in. And we also have another very distinguished person, as I can read it, Remy, from the Secretariat in Geneva of the UN Convention Secretariat. I don't know. I tried to just write to him. I don't know if he's around, but otherwise, I'd like to get him as well to say, perhaps say a few things about those questions that we have raised towards the end. And then we have really interesting questions in the Q&A space. So first, can I request Mr. Jain to quickly say or ask questions, whatever that he thinks, as a co-host?
Thank you, Chokkakula ji. In fact, it was very, very interesting to me, particularly because only few days back I went through all these Helsinki rules and this Harmon principle and this Berlin rules and all that. Actually, I was just going through because I was supposed to be a panel member in Mahidri Tribunal for selection of SSS. So in that process, I went through all those things actually. So now because it was only a few days back, so it was very interesting to just have a to just listen about them actually once again. So actually, I just wanted to ask one question that Mahadai Basin is more or less like a virgin basin, isn't it? So, but still there are a lot of disputes and it is not getting resolved agree, so quickly agree. In spite of the award by the tribunal, then again all the parties have gone back with so many queries, so many clarifications, and these things are still lingering agree. So, but it seemed it would have been very simple agree in case of Mahadai. But why it is happening? So, so can you give some ideas, Aragli?
Yeah, first you have to excuse me because I'm a lawyer appearing for the state of Karnataka.
Okay. So I think it is not a very
Okay, and
not on the ongoing case.
okay. So you may have some bias, actually. You doesn't matter, but still if you can give some frank opinion,
Yeah, maybe
all I can say is that both the states have filed appeal before the Supreme Court. Goa has also filed, Karnataka has also filed, and in the meanwhile, the government of India has agreed to publish the award. And to the extent the tribunal has permitted Karnataka to utilize the water, Karnataka wants to utilize, and it has submitted the project reports for clearances to Central Water Commission and the Ministry of Environment. And we all hope that you clear it fast and we utilize water. Thank you.
Right, sir. In fact, Jain Saab, I requested Mr. Katarki to speak on how these highly codified international customary law principles have been applied in the context of interstate river water disputes. In fact, it is partly that reason that because, in the flow, there is always, it's a matter of interpretation. Yeah. So it is also these are ongoing cases which are before the tribunals or the Supreme Court. So he's, he's bound not to comment.
Yes.
I agree.
Right.
Yes, sir.
Right.
I was not knowing that agree. I was not knowing.
So he's been part of it. Yeah. He came late. But can I request Mr. Haldar to come in? And is he there? I just elevated you.
Yeah, it was really very interesting, to be a part of this discussion, and at least the legal issues that is concerned with our transboundary disputes. Now, India has basically two kind of agreement or awards as far as transboundary international rivers are concerned, as far as one between India and Bangladesh on sharing of water. As far as both the agreements are concerned, Indus is working fine. There is no dispute. There are some small hiccups that we are taking care of. And as far as Bangladesh is concerned, we have almost giving almost more than 50% of our lean season flow to Bangladesh during the leanest period. So I think that is one of the very well drafted agreement between India and Bangladesh, and that is working fine. The major issue with us, is sharing between the interstate rivers. We have dispute in almost, all the semi-appropriated and, fully appropriated basins, and they are taking lot of time to resolve. So this is a serious issue, and we have to look into all these things, because until and unless, there are some agreement, there are some awards, all the development in this basins will be stopped. Secondly, I have a small question with Mr. Mohan because he was telling that he is a advocate on behalf of Karnataka in Mahadayi dispute. So whatever allocations Mahadayi, whatever diversion Karnataka will be making from Mahadayi to this Krishna, basically that quantity of water from the Krishna has to be given to other states because they can claim that share. So ultimately, Karnataka will not be benefiting much out of this Mahadayi awards.
Well, I'm not
Can I
sure.
answer?
Yeah,
Yeah,
sure, please. I
yeah,
thought you would not like to
There is
answer.
a provision in the Krishna Tribunal Award in
yeah, yeah,
1976, as well as the new modified award of Justice Brijesh Kumar in
Rajesh Kumar.
2013. If any water is imported to the Krishna Basin, then other states can have a claim.
yeah,
And
yeah.
if the states of Telangana and Andhra Pradesh were to make a claim, then that is a separate question to be considered whether that claim is justified or not. At the
Yeah.
moment, they have not made any claim. Therefore, we presume that they have no claim.
He's talking like a Karnataka line. But can I, sir,
Uh,
do you have
Mr.
any other
Can
question?
I?
Mr.
You
Vijay
know,
Saran.
Yeah,
Yes,
yeah,
Mr. Vijay Saran. Yes, yes.
yeah.
Yes.
Just it's a very small query. You talked about the existing rules versus equitable provision. I feel the existing rules now basically all the tribunals in India presently give much more precedence to protection of the existing rules. However, the existing use is actually dependent on the state of development of the state. Some states have developed earlier, some states have developed later, some were poor, some were rich. So, if a state has developed its irrigation facilities, created this existing use, and is claiming unauthorized use of water. So, what do you feel? Is the protection of existing rule or equitable rules? What should be the approach? Because in India, generally we tend to protect the existing rules. That is the theory. I am just asking about the theory.
Yeah, the law is clear that the existing utilization should be protected as far as possible, provided the utilization is reasonable, that it meets the test of rational duty, and there is no wastage or wasting of water. If it is able to show, if the state is able to show that it is not a wasteful utilization, it meets the test of modern technology and the modern requirements, then that existing utilization is liable to be protected, particularly where the utilization has taken place under some agreement or under the some project in which already upstream state has acquiesced in some or other form, then the claim becomes stronger. Suppose the utilization has been done surreptitiously by the downstream state without informing the upstream state, then it has a lesser weightage than the utilization which has been done openly in a transparent manner.
Sir, can I ask one more question
Sure.
on this question? Because I am chairman of Kashi Water Management Board also. Uh, Actually, when the state is using water for irrigation, suppose, and they are using it with, say, some old technology, without using the modern technology. So, as you told that they have to show that the use is reasonable, and with modern technology, whatever with best possible efficiency, they should use the water. So, the states have the obligation to adopt to the best efficient manner of water use. Is there
Yes.
obligation on that their part? So we
Yeah,
can
states,
yeah.
every existing user has an obligation to adopt the best technology, and only water that is required and adopting the best technology is his right. In fact, in the Western country, in America, the internal law is so strong. Whenever a permit is granted to a particular landowner, there they have ranches of 1,000 acres, 2,000 acres. The water is not a permanent quantity. A revision takes place every 10-15 years, and during the revision, if they find that now the technology requires, now the system is such, you can grow the same crop with a lesser quantity of water, then they have a right to reduce it, because nobody has a right to waste water. Only a right to utilization is there.
Okay.
That is how it is.
Thank you. Thank you, Mr. Katarki. Can I Now, quickly request Professor Rangachari, who came online, and some of the CWC colleagues would know him. Professor Rangachari, you are muted. If you could quickly come in and say or ask question.
Am I audible?
Yes, sir.
Yes, sir.
Okay.
Namaskar, sir. Namaskar, Rangachari sir.
Quickly,
I,
so
I,
that
before
I
we
want
ask the
to-
questions, one is complimenting Katarki, Mohan, for
Namaskar,
a
sir.
very, very nice presentation. I don't know whether he remembers or not. 25
I
years
remember
back,
you.
I rubbed
I
shoulders
remember
with him, Nariman and Parasharan in another context. So,
Correct.
so I learned quite a bit of law, being only an engineer in those contexts. Now, similarly, I'm happy to see my successors in CWC. Having been a very old fossil, I retired 32 years back from CWC. Therefore, these people have arrived just then. I'm happy to see
you
them.
just celebrated 90th birthday.
I know.
Please.
Thank you. Now come to the questions.
Yes.
Now come to the question. Now the 3-4 things, because you cannot cover all my questions in one session. It will take a lot of time. I put 2-3 questions in which I want to pick your brain so that we become educated better.
Right.
Number one, in fact, it has been an education for me. I was associated with the Helsinki rules, being an officer of the ministry dealing with the subject at that time in irrigation. Later, I have attended a number of the ILC meetings. Later, when the convention was prepared, till my retirement, convention was signed 10 years after. So, from those discussions, I picked up. The convention signed in 96, perhaps, was open for signature by some number of people within the prescribed days. India is one of those who abstained for some reasons. We are given our reason. India did not agree with that. 3 countries said no, definitely voted against, China being one. I am mentioning this by name because it is in our context a relevant question. Now, what I found was 20-15 years later, in some international conferences, I found the requisite number of signatures were not received and went on extending. But Mohan mentioned that it has received. Probably it's a guesswork. Many island nations are those who don't have a dispute with anybody are quickly recognized, and those who have a problem with water have not recognized. I would like to indicate what is the approximate number of people who have signed but who have now attached, agreed, accessed, whatever it is. My feeling is a number of them who voted for it in the UN have not exceeded it even now. This is a little enlargement on that one. Second question is about the hegemon. You talked about Mekong River Basin. India also is another one who suffers because of the water cover of Tibet being held by somebody who believes in the Hindi proverb, Jiski lati uski bhais. That means he who holds the weapon determines what is to be done. So we are not even getting any information. Every year during monsoon, you get information from Arunachal, not to speak of equitable sharing. They say you are flooding, this has happened, that has happened. We have no information from China in an official method. We are very happy to announce great agreement. Yes, they are now going to give us further data soon. But much more worrisome is the possibility indicated, which Mohan didn't elaborate, like the Ethiopian thing. In our context, what worries us more is the south-north diversion which China is pursuing. The possible Great Bend Dam that is likely to be coming. Even the smaller dams are being. So, what is it that will make China agree to that if there is a convention? The convention doesn't bind them. Whether we have any hold on that. Third question I want to ask him to think about is, he talked about if circumstances have vastly changed, you are entitled to reconsideration. You even mentioned what the Indus Water Agreement. You mentioned 3 rivers to India, 3 to Pakistan, but you did not specifically say 80% of the flows of the Indus, all of which were generated outside Pakistan, were given to Pakistan in the agreement which they got rid of in 1950s because they wanted the problem to be over. But has the circumstance changed? A lot of water was going to the sea. Also, they are thinking of using that with the new dams, the Amar Basha and other things, that Kalabag and all. So, Can India take the line that the circumstances under which original Indus Water Treaty has been signed have changed, asking for a relook within the context of how this can be redone? Not out of that, we are not going out of it. Indus Treaty provision also says the two countries can discuss and agree upon changes. Can we use that in a profitable manner? The lesser questions which my colleague Haldar and others pointed out, Bangladesh or other sharing, we have agreed to give something to Bangladesh of the water arriving at Farakka. We are not even sure how much water will arrive. There is one very vague clause in that agreement. Every effort will be made to ensure that the water arriving at Farakka will be more or less as in the past. We have no guarantee from Nepal whether it will send down the water. Nepal is one who have voted for at the time, but is now holding the Harmon Doctrine more or less, saying these are all our water. Would you throw any light that in the Indian context, that in India, Pakistan, Bangladesh, Bhutan, we have no problem with Bhutan at the moment, so Bhutan can be left out. China, Pakistan. Is there anything that we can do to improve our usage? That I would like to know.
Yeah.
Thank you, sir. Mr. Katarki, would you like to respond to all of this? We will not have time to respond.
I'll quickly respond. Firstly, I thank Mr. Rangachari. I know him for the last 30 years. He is the doyen of the Indian Engineering Services. The first question, that's as regarding the UN Convention, my information is that as from the net, the requisite number of states have already ratified. Therefore, the convention has come into operation. Second question, what can India do if China goes ahead and constructs the dam? Yes, correct. This is a serious question, and it is a serious question for anyone in the international field, because there is no court or there is no judicial body where we can go and lodge a complaint to the state China. Only thing that can happen is some kind of a good sense should prevail upon China to stop diversion of water if it has already planned to connect Brahmaputra to Yangtze and divert the water further up. So that is the only thing, and I'm sure the government of India, with all its diplomatic forces and technical people, will be able to actively pursue, and active pursuance of these kind of things are very important, because some kind of active pursuance and active involvement, debates, conferences, India and abroad, finally will bring a pressure upon China to mend its ways. This is how India has to do in the long course. The next question is with regard to the Indus. I already written an article, I will send it to Mr. Rangachari, that, and I also said that about 35 MAF of water goes to sea, and that water, though under the treaty were obliged to give, but in the context of the larger principle of international law, Pakistan is duty bound to sit and negotiate with us for use of that water or distribution between the two nations with regard to that water, which it cannot use. Therefore, India has a good case to negotiate, to call upon Pakistan to negotiate with regard to the utilization of those 35 MA of water. In fact, I also written that about 4 MAF of water, if we are able to divert from Chandra and Bhaga to the Satluj and Ravi Bass, we'll be able to solve all the problems which exist in India with regard to the Ravi Bass water, including the Aswal Canal. But that is a question which the ministry has to consider. In fact, in the way back in Anderson report in 1929 itself, connecting Chandra Bhaga to the Satluj was contemplated. Okay, so that can be considered, and a written article, I'll send it to that. Then the other one with regard to the Farakka, the lean season and other thing, that I have not studied much, that's agreement. I would like to go through, and sometime I'll call up and talk to Mr. Rangachari. Okay.
Right.
Thank you.
Thank you. Thank you, sir. Quickly, I have another distinguished personality here, Mr. Remy, from the Secretariat of the UN Convention on Watercourses 1997. With due apologies to those people who have put in fantastic questions in the Q&A space. And I also see very interesting questions in the chats box. I'll just allow Mr. Remy to come in and say a few things about how, particularly, I would like him to respond on these new challenges that Mr. Katarki has raised as those that the UN, the international law has to respond, how the Secretariat is thinking about it, Thank you, Remy, for coming in. I'm going to allow you to talk. Could you please come in and say, I mean, preferably to the question that we have about how the Secretariat is thinking about the new challenges like climate change and other kind of collective responsibilities, and any other that you might want to come. Are you there?
Srinivas, can you hear me?
Yeah. Hi. Yes, please.
Thank you. So Srinivas and Mohan, thank you for your presentations, and very happy to be able to join this conversation, and to all the distinguished participants who are joining in the webinar. It's really great to hear everybody's opinion. I guess firstly is just to clarify, there are two global conventions in force regarding international watercourses, lakes and aquifers. The first one, which has been referred to in the presentation, was the 1997 Watercourses Convention, which reached the quorum of 35 states in 2014 when Vietnam acceded. So that's the one that came from the UN General Assembly. And there's another one that's in force at the global level, which is the convention that I work for, which is the Convention on the Protection and Use of Transboundary Watercourses in International Lakes, which is otherwise known as the Water Convention. And that was adopted in 1992 within the ECE region, the Pan-European region. But in 2016, it actually became a global convention, open to accession by all UN member states. So there's a rare circumstance at the moment where there's actually two conventions, global framework conventions in force, operating globally on international watercourses, lakes and aquifers. And I just wanted to correct the record that I actually work for the Secretariat of the 1992 Water Convention, but also to say that the 1997 Watercourses Convention and 1992 Water Convention are seen as mutually complementary and reinforcing. And what actually is, so the Watercourses Convention doesn't have a institutional framework. So it's a treaty on paper and a legal framework convention. And one of the key differences with the Water Convention is that we actually have an institutional framework. So we have a secretariat with a meeting of the parties, and we also have, it's a living instrument. So we have, lots of events and meetings that we have in workshops where countries and all sorts of different participants from academia and civil society and NGOs come to participate. And that's, I guess, where we can talk a little bit about the value add of the Water Convention, in the sense that we have these, we have a task force on water and climate, where we tackle the issues that you're talking about in terms of adaptation to climate change in transboundary basins. We also have a working group on monitoring and assessment, where we talk about data sharing, monitoring and assessment in transboundary basins. And we have a task force on the water, energy, ecosystem and food nexus. So we have some of these kind of bodies under the convention. We're based in Geneva, but we have a global outreach, and we look to encourage countries, particularly riparian countries, but also interested stakeholders who are working on transboundary water cooperation, to engage in these bodies, because it brings people and governments together from around the world to share some of their challenges around shared issues such as adaptation to climate change in transboundary basins, and to work on shared solutions to some of these, and to exchange experiences, tools, technology and capacity. So that's just a little bit about the convention. And I won't respond to everything that was in the extremely detailed and rich presentation by Mohan, but just to say that there are three key principles embodied and codified in both conventions, and they are the principle of cooperation. I heard about the principle of equitable apportionment, which, as it's actually codified in the conventions, speaks to equitable and reasonable utilisation. So I'm not sure whether Mohan was referring to that specifically, but that's the one that's codified in the conventions. And there's also the principle of no significant harm. And they're really the three key pillars of international water law, if you want to put it that way, in terms of the global framework conventions. And these have been recognised by the International Court of Justice in cases such as the Hungarian dams case and the pulp mills case. And yeah, just really to wrap up my statement, because it's again an honour to join this conversation and really to hear about the perspectives from South Asia, and particularly some of the perspectives on the Indus situation at present, is just to say that the conventions are seen. It was interesting to hear about the Watercourses Convention mentioned in this presentation, but we didn't hear anything about the Water Convention, and also that there is a lot of there's a lot that's been written, and there's a lot that is currently active in the space of transboundary water cooperation and integrated water resources management on the benefits of both conventions being mutually complementary and working together as a global baseline of legal provisions for management of shared waters. And both conventions have been promoted by successive UN Secretaries General, calling on states to accede to those conventions to further strengthen the principles of international water law. And I'm happy to say that in recent months, Ghana actually acceded to both conventions at the same time, further demonstrating that there is interest from around the world in both conventions and also in their value add to countries that often have basin, either bilateral or multilateral agreements in place already. So I'll end with that in terms of my contribution, but I would also like to hear from our speaker, and also to any participants contributing in the webinar, to just see, many of the agreements in South Asia are either bilateral or sub-basin, and are actually rarely basin-wide in nature. And I'm just wondering, what, if any, do people see as prospects for some of these basins to be able to develop basin-wide arrangements? And also, as mentioned by the previous sir who intervened, what do people see as being the barriers to or challenges to countries in South Asia engaging with the global framework conventions? Because that would be something that I'd be really interested to hear, because there's definitely some learning from our side in the Secretariat to understand more about how we can engage with countries in South Asia around both conventions. So thank you for the time, and thank you for letting me contribute.
Thank you, Remy. I think Mr. Katarki, would you like to say anything?
No, I can just clarify. In my lecture, I did refer to the 1997 convention, and particularly I mentioned about the reconciliation which the 1997 convention brought about between the existing utilization, that is no harm theory, and the equitable utilization. And in fact, the same formula seems to be adopted by the Berlin in 2004 also. So I have referred to that. And only thing is that neither India, nor China, nor Bangladesh, nor Pakistan have acceded to this treaty. And therefore, it really doesn't help. But still, it has, as I already said, it has its lot of force. In fact, some say that if a treaty is being signed by majority of the nations, then it has almost as good as a customary rule of international law. With regard to the 1992, I didn't refer to that. That arises in a little different context. That's all that it may be paucity of time.
Maybe, that is true. In fact, it is difficult to cover them, but perhaps
it is very difficult to bring it in 50 minutes, 40 minutes. In fact, you had given me
40 minutes. So maybe perhaps Remy, you might want to, we can talk about possibility of you talking about Water Convention with reference to the Water Convention 1992, with particular reference to the Watercourses Convention 1997.
Certainly, yeah.
That would be very interesting. But Remy, just to respond to your question about it, yes, that is true. In fact, that it is mostly bilateral. That is what is the bilateralism is what you see in South Asia. It's not just within South Asia, but it is much more of particular interest for us, which has been referred to many times, is the interstate river water disputes within India. They're also mostly bilateral. I mean, you may have heard about a fairly remarkable record, a global record in between nations over transboundary rivers. But India too has its own remarkable record in terms of 160 or more, interstate agreements. And these are all mostly bilateral. And at this moment, we are now evolving towards dealing with the question about how do we bring in these understandings within a basin-wide framework. And we would be interested in looking at it, how this thinking is happening at the international scale. And then perhaps exchange notes that, talking about, because India itself is proposing a new river basin management law and, basin bill, which has been, I think, is being under consideration. So there is a great deal of thinking about it, and perhaps we can exchange notes on that front separately. But Mr. Katarki, we are past the time, but there are really very interesting questions in the Q&A space. I hope that you have had a chance to look at it. Quickly,
Sure.
if you can respond, that would be nice. And I mean, it would be unfair. You can even prioritize these questions. In fact, in the chat box also there are questions, but we can't take them up at the moment.
Yeah, one of the question is Mr. Gupta has asked. Jaideep Gupta.
About non-state actors, yes.
Yeah, non-state actors. Yes, I do feel that before a nation or a state goes to the co-riparian state for a treaty or a discussion, they have to consult their stakeholders on the water and the persons interested, engineers, hydrologists, lawyers, all the persons who can contribute to the understanding the rights and the interest of the nation. That would always help. In fact, I had taken a view while discussing with the T-Star River that when West Bengal Chief Minister said you cannot enter into a treaty without consulting West Bengal state. It's correct. A legitimate question she raised. If not people, at least the state of West Bengal should be consulted before you arrive at a treaty. Although it is not binding on the Union of India to agree to all the proposals which the states make or the non-state actors make, but a duty to consult indeed exists in a sovereign nation. They must consult with all non-state actors before they put up the proposal at the international level. Right. Then with other question is with regard to the China international border and okay, if the catchment area is 80-20 and all, well, it is like this, the water cannot be really distributed based upon the catchment area or the water contribution or area of origin of water. They can be a factor to some extent in understanding. The water is really distributed based upon the needs. It has to be shown that a state needs the water. If it needs the water, then only the consideration of distribution of water arises. And finally, the equitable share of a state is based upon not because what it contributes or the geographical area it has got, how much water it requires. And if there are two competing requirements, then how to ration that water is another matter. That's how the thing. Then apart from that, there is one question with regard to the China. If China refuses to enter into cooperation with India, what are the options for India? That's how I guess the question is. Well, it's really a difficult question in international field if a nation refuses to engage. But the effort of the diplomatic community is to persuade China, is to build such a pressure at the international level as they think it is possible. They know it better. And to make China finally mend its ways, to cooperate with India, share the information, and also to finally share the water in such a way that I do not suffer any injury and the state below me, Bangladesh, does not suffer any injury, so that there is equitable utilization of the water of Brahmaputra. And if there is a threat and there is a possibility of diversion of water by China to the the South-North project, which they have already implemented by connecting Yangtze to others. Connecting Brahmaputra to Yangtze is not a big problem. They might connect. Therefore, India has to exercise all its alertness and bring pressure upon China. See that the trans-basin diversion of water of Brahmaputra does not take place, which is detriment to the interest of India. Thank you. That's all I have. I think I answered the questions.
If there are any, I mean, since we have anyway, perhaps we can close it by 5:15. If there are any questions that we haven't been able to respond to, I mean, those
They can,
people who
of
have
course,
put in the chat box.
Yeah, there
they
are a
can
couple
always
of
write.
questions. Yeah, there are a couple of questions. Also regarding Lake Llano is there, it comes in conflict with the share of affected state. If a principle related to the Llano is in conflict with equitable share of affected state. See, the Lake Llano principle is that the state is entitled to proceed unilaterally. That unilaterally, a right to proceed unilaterally does not mean a state can do something beyond its equitable share. It is bound by the rule of equitable apportionment, and it cannot develop water beyond its equitable share. So that's how both the principles of unilateral construction and the question of being bound by equitable share are to be considered. Right. Then after
There
this,
is also, there are a couple of questions on India, Nepal in the chat box. In fact, Zoom webinar chat by one Arun Shrestha and then one Jan Kirk. Is that
I'm not familiar with India and Nepal much about, except that what we read in the newspaper. That may require a specific study into that. But if there is any general question asked, I can answer. I don't see India, Nepal. Where do you see that?
That is Arun Shrestha's in the chat box.
No, I'm not having. I'm
following
the question and answer. I'm only seeing the question and answer.
No, please look into the chat box. There is.
What do I press for the chat box? I don't know.
I mean, there is a chat separately. But why don't I copy this? I hope that I can copy this. And can I copy this? And
do one thing. Please share with me. I can also give a written answer to all these things at a later stage.
No. In fact, let me just see if I can actually. I'm allowed to do this. I'm trying to put it in the question. No.
Yeah, if you can translate the question to me, I can answer.
Okay. Would it be possible to comment on Koshi and Gandak agreements between India and Nepal? Clearly, there are disagreements between two countries in terms of water allocation, inundation. How to utilize the equitable apportionment principle in this case? That's quite a broad question.
My apology. I am not familiar with this agreement. I wish
I can say that Koshi and Gandak agreements are specific project implementation agreements, because the project was in the border or touching their territory in one side or the other. They are project specific. They are not those which apportion the water or beneficial appropriation of water by one or the other. That is not to be confused with the agreement between Nepal and India about equitable utilization of the waters of the rivers. One more supplement I can make about what Mohan said of the Tista thing. Consultation with West Bengal government is a requisite. I can say something because I was involved in that exercise. As a member of the Indo-Bangladesh Joint River Commission, there was a committee, Indo-Bangladesh empowered body, which was to specifically discuss Tista sharing. I and my counterpart in the JRC, we discussed. As I told you, they are all 30 years back. This is not current history. Between 1980 and 85, an agreement was more or less drafted, but political consideration didn't allow it to go forward. But in my personal view, I think it is not proper for India to delay a sharing arrangement with Bangladesh on the Tista, because this is a question which is hanging fire from the very first 1960 Pakistan days onwards. 1960 at least, whatever is original, you cannot postpone this. So it is not fair to say Government of India have not consulted West Bengal. All the governments prior to the present one, then the present Chief Minister of the state have agreed more or less in the drafts. Drafts have been prepared. They were thought to be ready for signature even in 1986. So it is a consultation with respect to be continuous with every successive government or not, I do not know. That is a supplement point.
Okay.
Thank you, sir. Always, through the lived experience, you can always bring in new insights. But there is another question, which is about ethical concerns. Have there been any? This is a very interesting question. Perhaps this is about, you seem to be voicing the questions of ethics in terms of principles of equity only. Has there been any reference to that kind of ethical concerns in your experience as a litigator? I mean, I'm just totally rephrasing it. I hope that it isn't I'm doing justice to it. But otherwise, let me. Are there any instances, Mr. Katarki, where the litigations involved ethical questions?
Yes, they do involve. All parties have to conduct the case in a transparent manner. No party should refuse information sought by the other state. We have been very strict about it. In fact, I must tell you, in Kaveri, which credit to all the states, one thing was agreed: no state shall deny information to others. There should not be any order by the tribunal to give information. We should volunteer to give information. Therefore, tons of volumes of information was filed by both the states, Karnataka and Tamil Nadu. And at no stage, neither Karnataka refused to give information, nor Tamil Nadu refused to give information. Neither we refused to show any project, nor they refused to show any project, except once Karnataka wanted some kind of an aerial trip, which Tamil Nadu refused for a different reason. Otherwise, things have been always transparent. What stand we take in a litigation is our privilege. That is the client's instruction. But whatever we do, we must do it in a transparent manner and adopting a fair procedure. At no stage a lawyer or a state is a high state here, should indulge in anything which is inconsistent with the principles of ethics or transparency,
So,
put it shortly.
yes, in fact, there could be an entirely different conversation around ethics and these disputes. In fact, that itself could be a separate conversation. So we would,
in fact, apart from the states, whenever the press people come and request Canada government, we have always paid information. At no stage in last 30 years, we have said no to any pressman or any individual. Even if individual writes a letter, we reply to that.
Right. Yes. Thank you so much, Mr. Katarki. This is fantastic. And thank you all for staying 20 minutes beyond the time that we have given. Plenty of attendees still there and actively chatting over in the chat box. But we have to end it here. Thank you very much for joining us today.